Okay, guys, you're live.
Thank you. Let's see, 1, 2, 3, 4, 5. I think we're just missing Jocelyn. I'll give it 1 minute.
Hey guys, also just before we start the meeting, I'm going to have to drop at 12:30 because I have a work call that I have to get on. I apologize. If we go later or I finish earlier, I'll jump back on at the tail end.
Okay, thanks.
I might be in the same boat. I'm not sure yet, though.
I'm going to go to the section where I think we're going to start after preliminary business. Yeah. Okay, I think I'll wait till, we're at 12:03. So is there a motion to formally open the meeting?
I make a motion to open the meeting.
Second? Can I please get a second?
I second that.
I second it. Okay. All in favor, please say aye or raise hands.
Aye.
Aye.
Opposed? Okay, we are formally in session. Thank you. I am going to ask that we postpone the review and approval of minutes of December 9th. I have not had a chance to review them in their entirety. So we'll, unless there's any objection, can we postpone that? And if, on the other hand, if there are any comments to be made or additions to be made, please add those to the Word draft that Brian sent, and we'll review them at our next meeting. And I will ask whether we need to meet twice next week or just have the regular Friday meeting, but we'll hold off on that for now. Regarding the
All right.
committee's solicitation letter.
So I just wanted to say for the minutes, starting this meeting, I'm putting a notice in the beginning saying that these minutes are intended to be a mere summary of what happened. And then for the best source of information, please view the recording of the meeting.
Perfect.
Okay, I actually have a suggestion on that, which I will include
On the
in. I did start to review the draft of the minutes for the 9th, and I plugged in a legend, which is a little simpler than the one you've suggested, Brian, and it merely states that committee meetings are recorded on Zoom and are therefore public record. I'd rather not editorialize as to what we strive the minutes to be. So,
Right.
but all of you can review that and determine which is more appropriate, or if you have an idea of your own. So with regard to any other comments on that before we move on? With regard to the status of the mailing our letter and the extension of our time, I believe you saw the email I sent to the Board of Trustees this morning asking for an extension of time and for communication of our letter to village employees. Sally's just informed us that it will be on the committee's agenda, and hopefully we do get that extension. Any other comment on that, or comment with respect to Brian's list of organizations, additions, deletions, comments of any kind? So
The only comments I have are that I know that some of those people who are listed as leaders of community, certain neighborhood associations are no longer even living in the community, but I don't know who the replacements are. So I don't know how that helps, but
Or, thank you.
Well, it'll save us whatever 58 cents or whatever the current postage is for
Yeah.
us or the village if you just let Brian know.
I can go through that and just let him know who's no longer the head.
Yeah,
And
that
in
should
some
just-
and in some cases, they may be able to forward it on to the appropriate person. But in a number of them, I know that there are, I think, 2 or 3 that are no longer living in the community. So I don't know who's replaced them.
Then those should just come off.
Okay.
Yeah.
So
All
that'll
right.
save us.
Okay.
And then a few of most of the organizations or associations didn't really have websites because they're like, I guess, just a group of people. So they don't really have their own website.
Right.
Okay.
Revising it.
Sometimes some of the community neighborhood associations have like almost like an email list
Mhm.
that they send out to.
Hopefully, when the village mailing list is reached, our own list contacts we have will hit some kind of a critical mass
Right.
that satisfies our duty to inform the village of the work that we're doing. All right. Let's move on to agenda item 4, which is our continued work on review of the proposed amendments to the code. Let me first say that at our meeting on Wednesday, I said I would adjust the language to make clear that seeking a formal opinion is seeking a written opinion of the board. I haven't done that yet. I will address that. And I will also spend more time looking at the quote unquote who to see if we can unify that collective group throughout the code so that we are consistent. So that's still for me, a work in progress. Let's go to, I have highlighted here. I hope you can see it on your screen.
Wait, Dan, before we start new stuff, I had a follow-up. And I hope I followed up on the right thing. For President Future Employment, I believe Jocelyn was questioning the 2 years, if that was too long. So I took a look at the state model code and the 6 municipalities we've been looking at. The state says 2 years. The town of Mamaroneck says 1 year. And the other 5 don't mention any time frame.
Town of Mamaroneck says 1 year.
1 year, but the state model code says 2. So
Probably
we're in alignment with the state.
I wasn't falling on my sword over it, especially after comment that that's fair as a past. From his perspective, which is more important to align to, the state or the town, I guess is the question. When I heard it was not a big deal, I think we just need to make the decision. And I'm fine with either, of course. I just was pointing out it seemed like a long period of time to hold someone accountable post their employment. But I guess during board members, I understood it, but I felt like an employee that on post-employment obligation.
Right, but maybe I reviewed the wrong section. So I looked at K1 And it's really talking about accepting a position that would have dealings with the village. But if it's disclosed and the Board of Trustees approves it, it's okay. So there
Right.
is that opening.
Correct. You can get a waiver,
Yep.
but you have to go through the process of getting the waiver before accepting the job.
Yeah, I read that too, and I'll be honest with you, I understand it's a long time, but I think it's better if we start out with a more strict time frame, and then they can adjust it down the road. But I saw it in the model code too, and I think 2 years is acceptable.
Do we have, I didn't see the waiver as part of the code we're reviewing though, like that would concern me again, just having a process for the waiver that's consistent, but that's not in our code, so.
No, but what the code says, I'm not going to read the whole thing. It
Yep.
says unless such potential employment is disclosed to the Board of Trustees before being accepted by the officer or employee and is approved by the Board of Trustees. So that's the waiver. And I can include something on this for the racing matrix to delineate the process.
Jocelyn, do you want to give that a further think and take a look at the matrix when it's
Yeah.
done, and we can
Yeah.
have a further discussion at that time and decide what the sense of the committee is.
Yeah, I
Great.
mean, I think part of the concern is you have the potential, the potential for an employee who is granting contracts to accept a contract, and a job with somebody whose contract they're reviewing. And I think that's a concern as well.
Okay, are we agreed that we can revisit this when we have the matrix in front of us and prior to our finalizing our views?
Yes.
Okay, great. Any other matter that is left over from a previous meeting or section of the code before we pick up on the section that I have in front of you? Okay. With that in mind, let's look at 21(7)D, which is indicated here, sets forth the prohibition regarding holding office in a political party or acting as a lobbyist. A lobbyist is not defined anywhere. And what we have done, or what the code does contain, are provisions regarding appearances before the village as part of their employment. And what I've suggested is that we substitute, instead of lobbyist, we use the phrase that we've used in other parts of the code. But if we don't, we have to plug in a definition for what a lobbyist is.
But does the state define what a lobbyist is?
I didn't look at that.
Okay.
I don't think so, John. I don't remember seeing that. But that could be me having a senior moment. I'm not sure.
No, I don't necessarily mean even in the model code. I mean, maybe in other sections of code.
It might, and it probably does somewhere, because the Joint Commission on Public Ethics, also known as JCOPE,
Yeah.
its life is devoted to fining lobbyists for their indiscretions. And I will, full disclosure, I co-wrote a report on JCOPE for the New York City Bar Association, which was very critical of JCOPE and what it is and what it does. But that's not my point. My point is that there's going to be a definition of lobbyist somewhere. And why don't, Ellen, why don't you and I look to see if we can, I know we'll find it. So why don't we look at that and see then if the language is more appropriate here, or if we should simply cut and paste the phrase and context that appears in other parts of the code.
Yeah, I mean, just to be clear, I did look up, just as we were talking, lobby, I Googled lobbyist in New York State Code, and the JCOPE report and definitions came up.
Okay.
And, I guess we would need to determine whether or not it would be consistent with what we're trying to accomplish, I guess.
Okay. When all is said and done and we get together in person for drinks, I'll tell you all about JCOPE.
Please don't.
All right. So let's we go from D to 21. Let me get down here. 2114. That's 13. There we go. 14. Okay. And it's actually A and C. No, A and G that we should be looking at. Now, when I looked at this section, I wanted to clarify the committee's authority for referring matters that came to its attention. This is an important section, not that nothing is unimportant, but this is particularly important because what happens if you are call it an administrative law committee or a committee that reviews civil matters, something may come before you where the decision of the board is, this allegation is so serious, we need to send this right away to a law enforcement body. We need to notify the Attorney General. We need to notify the, could even be a federal agency. And so my goal was to make it clear that for purposes of referral, the committee had this, not that it didn't have the authority before, but I wanted to clarify it. So in 2114A, I called it referrals for disciplinary action, and I expanded the bodies to which a referral could be made. And under G, I try to make clear that who the ethics board may refer matters to. So I open it now for any discussion, questions, comments on that.
I'm sorry, can we go back a little?
Where do you want to go?
2110, I think it is. Or wait. Yeah, I think it's 2110. It's about the members of the Board of Ethics.
Bear with me.
Sorry. I should have mentioned this earlier.
Here we
About
are.
how like two people or two members of the same, or up to two members of the same party can be on the Board of Ethics. I just want to clarify that like it doesn't have to be like two Democrats, two Republicans. It just can't be like three Republicans or three Democrats. And then I was just thinking like someone can change their party like right in October just to get like change their party, so they're then eligible for a seat on the Board of Ethics. I just wanted to ask the other committee members about their opinion on that.
Brian, to that point, if someone changes their party affiliation after being placed on the board, we could then end up with 3 Democrats or 3 Republicans or whatever.
Yeah, so how does that work? I didn't think of that situation, but how does that work? Would then the person have to like leave?
I wonder if that is the province of our work in addressing the code, or whether by operation of law, it calls upon the village attorney or the trustees to take action. Is it necessary for us to, just thinking out loud, is it necessary for us to address an imbalance that occurs by operation of law, such as your hypothetical? What happens if there is such an imbalance?
In
Plus-
my mind, that would be a procedural thing, not a code thing. The code says X. And it's a procedure to ensure that X is supported.
Well, I mean, going back to Ellen's hypothetical, I think the party affiliation change doesn't go into effect until after November. Like, I think it's like so many deadlines you have to follow for it to go into effect after November, like the November election.
Just again, thinking out loud, if a member of the board changes their party affiliation and they, by their action, create the imbalance,
Mhm.
that may constitute a forfeiture on the part of the person changing their registration.
How about if
Now
I,
they have become ineligible.
how about if I include that in the RACI matrix as
Yeah.
well?
Good.
Yeah, that's a good idea.
And it's not part of the code, it's just a procedure supporting the code.
Okay. Thank you, Brian.
Thank you.
Brian, anything further on that, or should we
No,
proceed on to?
Yeah, please. Sorry. I should have brought it up earlier.
That's quite all right. We don't stand on ceremony here. So going to 21-14, A and G, any comment on that?
Dan, I hear what you're saying. I would like something more definitive as to exactly who the matter should be referred to as the first course. So it takes any discretion away, and I think it should just be a decision. If it's the district attorney, if it's the attorney general, if it's the U.S. attorney, and I think that there should be consistent referrals to the same person. That person can always say that they're not capable of handling this, or it's better handled by one of the other agencies. But I don't think we should allow this to be a spot where they can pick and choose. I think it should be very clear. For a matter that's got to be referred regarding possible criminal conduct, the first course of action is to call, and I'll offer the Westchester DA. Second would be the Attorney General. Third, the U.S. Attorney, or whatever order the group wants. I just don't think that there should be picking and choosing.
I would respectfully disagree, Mike. First, every case can be different, and it may be very obvious in a case that the referral is a matter of state law or a matter of federal law. And therefore, it may be very clear to whom or to which office the referral should be made. Secondly, having, I served with the New York City Department of Investigation for a few years earlier in my career. And we had a we were not we did not try cases. We referred our investigations to different agencies, and we made a judgment as to the appropriate agency. And at times the agency would say, no, that's not us. You need to go elsewhere. So I think we would be restraining the board if we gave them a pecking order. And I think it would be more appropriate if they had the discretion to choose the agency themselves.
I hear what you're saying. I just know that many times some of these acts can violate both state law, federal law, and I just think it's better to take the decision from them and it puts that into somebody else's hands to say, yes, we want this, or no, you're better off there. I just think it's more consistent that way. And I don't care what the order is. It can be any of the entities or whoever anybody wants. But this way, the board is never, say, left determining who it should go to, and then their actions are never questioned as to why did they go to one entity and not the other.
Any other views on that?
I mean, I do agree. I mean, I think it should be, I think it should be directed to, you know, at least, I agree that there are many different levels where this, you know, where something that's been discovered by the ethics board could be investigated. And frankly, I think once it's discovered that there may be an issue, and I think this is where the ethics board has gotten a little off track sometimes. Once it's discovered there may be an issue, many of the things that they've looked at should probably be referred to a, you know, the Westchester County District Attorney. I would say probably first, because that's the most local. But it removes their perception of being the judge and jury in a situation.
So, John, is your view that we should provide an order of referral or not?
Yeah, no, I mean, I do think we should probably provide an order of referral. I think you'd probably get the most, you'd get a decision whether or not to investigate or to pass it on to somebody probably quickest from the Westchester County District Attorney. Whereas if you go to the state, it may take longer, and trying to get an answer faster is probably in the village's best interest.
Any other views on that?
I think from a consistency perspective, that makes sense.
Okay.
I guess I just want to say that I guess like every case can be different. So like I don't want to have too strict of a language. Like I think there's some middle ground here. Like maybe we can be like the order is blah blah blah, and then be like, oh, nothing is like the second sentence or third, nothing contained in this chapter shall be, and then that should also include the Board of Ethics ability to refer any matters to any appropriate authority. So I think there can be like some middle ground. Like there can be an order and then like a catch-all phrase saying that they don't have to follow this order, I guess. I don't know. I'm trying to come up with the middle ground.
And I hear what you're saying, right? Just two things. I don't know, in my mind, if we need to create an order. I just think it's got to be, this is who it's referred to for determination, and then that's consistency. So I don't want to I don't think it's right that we say, okay, you call the DA first, then one of the other two. I just think we go to one, and then that person says, yeah, it's appropriate for us, or no, you should go to the U.S. attorney, or they say, no, the matter's closed, right? And then it goes back to the ethics board.
I mean, hopefully we don't have a situation like that ever.
I
That
think
they
this,
don't even have to get involved.
I think this is one where we're going to punt this to the Board of Trustees and offer both points of view. I feel fairly strongly about this. I respect your views on it. And perhaps the best thing to do is go to the elected officials and say, here are two alternatives. There are views. We have views on both. This is up to you.
I'm good with that. I would make that, if that's a motion necessary, that we go forward with that. And just so you know, my only concern is it doesn't put them in a spot where they have to say, yeah, we did this. And, you know, your ability to interpret these laws and these regulations might be different than, say, myself, right? And so you might have a greater level of expertise. And depending on what the board makeup is and who's voting on it at that time with recusals and whatever, it just creates a standard. And with a standard, it's either followed or it's not. So, but I agree with you. Let's send it to the board, and I would make a motion if that's acceptable to you.
Sure. So if your motion is to recognize that there are differing points of view on this and that we will refer this section of the determination of this section to the Board of Trustees, is there a second to that motion?
Second.
Any further discussion on this motion? If not, all in favor of the motion, say aye or raise hands.
Aye.
Aye.
All right, that motion is carried. Thank you for that, Mike.
I'm sorry, I have to stop for that call, and I will get back on. I apologize.
Very good. Glad we got him when we had him.
Actually, Dan, you just scrolled too far. So H, that's the one you reached out to Mark on, because to me, this is totally contradictory.
Right. Yeah. Yeah, this one still doesn't make sense to me.
Yeah, so I mean, I think this goes to the heart of the matter. Does the Board of Ethics or the Ethics Board have the power to enforce anything?
But it doesn't say enforce, it says take any action.
Yeah, I'm assuming an action would be an enforcement action.
But it doesn't say that, John. That's my point.
Right,
Action could be start an investigation.
right.
Action
Or-
could be a referral, like we just discussed.
Or an action could be the issuing in a subpoena.
Right, but it's not clear, is the
Right.
point that I'm making.
Yeah, no, I'm with you. In the model code, what is this section?
I don't recall seeing anything like that in the model code,
Well,
but I could be wrong.
let's do this. Let's take a look at the model code to see if this belongs, if it's included anywhere. If it's not, then I think in our report, we tell the Board of Trustees that we find this no explanation for its existence, and we consider it to possibly conflict with other provisions of the code, and perhaps should be struck. Any view on that?
Actually, I just pulled up Mark's email, and he says it's linked to section 21-13E.
All right, let's go up there. Well, that's as clear as mud.
Well, I think this is actually clear. This is saying the ethics board can investigate the ethics board. I don't think the other section refers to just the ethics board. I mean, this I don't have a problem with. It's the other one I have a problem with.
Yeah, what I meant by clear as mud is that insofar as its connection to the other section.
Ah, got it. Okay.
No, I get this one. Not that I think it's saying, but I get it.
All right, then let's put the other section before the board as well.
I think that's right in the absence of, and again, I asked Mark Ettinger, I also asked the village attorney, and I think that's the second question I asked of the village attorney for which I have no reply. But I think that's one we put to the board and say we don't get it. And in the absence of a credible explanation or an understanding as to what it means, it is not only vague, but it may undermine the intent of other sections of the code.
Yep.
Okay, well, thanks for short stopping that one. Let's go on to 16A. Formal advisory opinions. We've discussed this before, and what I did here was to make clear what an advisory opinion was, and make clear, I think, our sense and agreement that there are only formal opinions and no party can allege that they got a verbal okay from someone on the board or the board itself, and therefore was binding the board or the village to a decision.
Should we expand? We've got upon written request of any officer, board member, or employee or department head. Should we expand that to include all people who are covered by the Code of Ethics?
What about a resident?
I've indicated there, or any person or business entity. So I've
Okay.
taken in the world there.
So I think that's,
All right.
Yeah, and again, there's no such thing, right? That what we're trying to make clear is there's no such thing as a verbal communication being binding, and I think we cover that.
Yeah,
This needed coverage, so I think I like how it's written, assuming it encompasses everybody. The world.
The
I-
only reason why I was suggesting expanding the beginning, even though it's covered with any person, is it's inconsistent with how we've laid out other parts of the code.
I would agree we should be consistent in every place we define it. I think we're trying to make it easy on ourselves by defining it in the beginning, and
Yep.
the group will be the group, and then any person or business entity would be the additional here. So I don't think we always had department head, right?
No, and a department head's an employee. I don't know why that needs to be specified.
It's covered as, they're covered as employees. I don't think we need that. Well, let's just agree we will be consistent and do the read through every time we define this group. The only thing this adds inquiring parties, right? So that's additional.
Yep.
I will, in our final run through, or as part of our continuing work, is to unify the who on this so that we are consistent.
Okay, that's great.
And the goal here was I wanted to make clear that anybody in the world could make an inquiry of the ethics board, because someone seeking to do business with the village of Mamaroneck, someone planning to move to the village of Mamaroneck, anybody can go to the ethics board and get an opinion within the jurisdiction of the board.
So in
Okay.
the last sentence that you added, which I'm fine with, but no verbal communications, should we put and only written advisory positions as you have above?
Yes, I'm going to put that in. Okay, that's in.
Thank you.
Good point. Without objection, that is.
Yes. Can we discuss section B now?
Yeah.
So what I'm kind of confused about, or not confused, but the ethics board, how are we going to deal with an ethics board that initiates their own investigation? Or is there no such thing?
Is your question, may the ethics board on its own initiative identify a matter and undertake an investigation, or merely be reactive?
Correct.
That's a very good question.
So if we're saying that anyone can reach out to the ethics board, whether it's a resident, a business entity, an employee, et cetera, et cetera. So anyone can be an inquiring party. I would say that a member of the ethics board can become an inquiring party and then would have to recuse him or herself from the board for that matter only.
And they would have to follow the same process of
They become an inquiring party.
yeah, so they'd have to go through the written process, ask for a written opinion on this particular issue, and
Right, and they can't be party to the response of their own question.
or the discussion.
Yep. That's my opinion. And you're right, I don't think we have that covered anywhere.
Well, if a member of the ethics board wishes to get an opinion of the ethics board on a matter, I'm thinking out loud, haven't we defined that situation previously because they now have an interest and therefore must recuse?
I thought that was other board members' recusals. We could take a look at that again.
I think the bigger question which John raises, if I'm correct, is at an ethics board meeting, a member says, I believe that the land use board or another board by its nature is violating the uh, the, the sections of this code of ethics, and we, the ethics board, should launch an investigation into that. Do they have that power?
Yeah, I don't know how to answer that question because I think we travel down a bit of a rabbit hole when we get into that.
Well, here's another one where we can look at similarly situated codes of ethics or boards of ethics and see whether explicitly or implicitly they have the authority to conduct their own investigations.
Yeah.
You could have everything from a good faith watchdog entity protecting the ethics of the village to a runaway wildcat investigative body and anything in between. So that's a fair question to say. I think probably, my own opinion, we should be guided by what the current, if there is a current standard practice, and try to determine what the model codes intended as to whether the boards of ethics should be reactive or proactive.
I would agree.
So we'll look into that. Let's see, Jocelyn and Ellen, you have been looking at other codes of ethics?
I've been looking at the other municipalities and the model code.
Yeah, well, let's do that. I think that'll be instructive for us.
Yeah, I'll take a look.
Okay. Are we anything further on section 2116? How about,
Can you scroll back down to the judicial section? Little 2117, I think.
Yep.
I mean, I don't, we have this issue of the ethics board being able to grant or request documents via a subpoena. But there's no appeals process for somebody who's been a person who if the ethics board requests documents via a subpoena or requests a person's presence, there's no way in this code for them to appeal that subpoena.
you mean if the board has subpoenaed somebody, they don't have an appeal?
If the way this code is written right now, the ethics board has subpoena power. They issue a subpoena, an employee, resident, whatever, is issued the subpoena. There is no way for a resident to appeal that subpoena. No judicial review of that subpoena. Or
Isn't
no-
there, couldn't one go into New York State Supreme Court or New York and move to quash the subpoena?
It sounds, the way that I read the code, it basically sounds like the subpoena is absolute. So it just a consideration for us to look at, because it doesn't, there's no process there in the code for somebody to challenge the efficacy or the legitimacy of a subpoena.
Maybe an easy fix to that, John, would be to include a provision which recognizes the right of any subpoenaed party to seek relief through the provisions of the civil practice laws and rules.
Yeah.
That would recognize, if it's not there already, it would recognize that the subpoena power of this board is subject to judicial review.
Okay. I think, I'm not sure how that issue gets resolved, but I mean, I just, it may be a concern in the future. That's all.
I
Yeah, but
think
doesn't that get to the question of, does the Board of Ethics have the right to issue subpoenas?
well, they
Well,
do.
well, currently they do. Yeah,
Right, I meant should they?
Oh,
I
I
guess that's,
think it's essential. I think it's essential, but it should be tempered by the right of an individual to seek redress.
and also, is that in the model code too, or is that not in the model code? I don't know. I went through the model code a couple of weeks ago pretty carefully, pretty quickly, and I didn't see anything about subpoena in the model code. And in fact, in most of our neighboring communities, when Ellen had collated everything, I don't recall there being other communities around us that allow the ethics board subpoena power.
Since I'm already going through, and I already forgot what I was looking up, the other codes, municipalities and the model code, I'll take a look for subpoena power also.
Yeah, and this may be another case where it's laid in the lap of the Board of Trustees to make a decision about whether or not that's, important to them.
Yeah,
Yep.
I would be very reluctant to strike that authority on the part of the board. You've taken the teeth out of their authority if you do that.
Right,
But I
but it's not even mentioned that we've given them that authority.
It's silent on subpoena. Unless we think it's covered with any person aggrieved by a decision, a subpoena is a decision to file a subpoena, maybe we just expand there.
Yeah, that's what I was thinking, because it, sorry about earlier, but it says decision by the Board of Ethics. Anyone can challenge a decision. So maybe we should either define decision in the beginning or define decision in that section, like have comma including a subpoena, comma.
There it is in 2113A.
Or does decision just refer to like a final order? I'm not sure. That's what I'm wondering.
Sorry.
Well, right now they have the authority. And I think what is, my own opinion is, what I think is fair is to temper that authority by making clear that a subpoenaed party has relief available to it. I mentioned that the major controversy that possibly leaded to the creation of this ad hoc committee is not a subject for our review, and it's not. But I think that if we took this authority away, we'd be, well, I think we'd be ignoring it. Let me just withdraw that comment completely. I just think we should leave the subpoena power in and provide some relief for an aggrieved party. And John, I think that's a really good point, a very important point to bring up that you've brought up.
But my concern with the ethics board being an investigative body is that they're not really, and I think Mike would go along with this, and I think this is part of what Mike was getting to, was they're not skilled in the investigative process, and laying the investigation at somebody else's doorstep is probably better and more enforceable and probably more effective, and also doesn't put the ethics board in the position of being essentially viewed as, you know, a prosecutor, hearing officers, and, you know, a judge. So I don't know. I think I think the ability to issue subpoenas creates an environment where they're getting into an enforcement area that they don't really have the power to enforce. That's all.
Yeah, and my concern is that matters that may go before an ethics board in the little village of Mamaroneck are so minor as to invite the indifference or avoidance by the Westchester County attorney or the Westchester County district attorney. So I think they have to have some authority to ask for books and records in order even to determine whether a matter is worthy of referral. Well, this is an issue I think we have to render a finding on or render an opinion on. Need not be a unanimous one, but I do think that once you give a body subpoena power, you have essentially you have given them investigative authority. The moment you issue a subpoena and call for the production of a record, you are conducting an investigation. So if you take that away, all you are leaving them with is a referral power. And if there is a complaint made and the complaint regards the ethical conduct of a board member, employee, or officer, and the record that the board needs is not in the custody of the village, the only way they're going to get it without consent is by subpoena. Then you may have tied their hands.
But I mean, if the ethics board issues a subpoena and gets a document that demonstrates culpability by somebody, then they also hear the case itself, it's like they have the ability to investigate, then they also have the ability to discipline. And at some level, those roles should be split apart. If they're going to have the ability to subpoena, which we may or may not agree on eventually, then I don't understand how they are the arbiter of, how they issue a resolution to whatever culpability they find. That's, it's a little bit unfair. Somebody's a resident, as a board member, I'm on the planning board or the zoning board, and I'm an attorney, and one of my clients is going to benefit from a decision that I make, even though it's not the exact decision that I make. I have a client that's in a parallel situation as to a decision that's before the planning board. That gets brought to the ethics board. The ethics board asks for documents. I supply them with documents. Then they turn around and they have a finding that I violated an ethics, I've created an ethics issue. So they've got the ability to investigate through the subpoena power, and then the ability to make a decision. It's a little bit, I think we have to be careful with that. That's concerning.
But I think administrative bodies do that all the time. There's a whole body of administrative laws. So if you work for the Department of Health and Human Services, or you work for the New York State Thruway Authority, I believe they have, well, of course, you have administrative law judges who can call for information. Although I may contradict myself by saying that those administrative law bodies are maybe not part of the agencies themselves. I think in some cases they are at the admin level. If Health and Human Services gets a complaint, their IG office conducts an investigation, and I believe they make findings, they subpoena information, and then they recommend, and then they penalize.
Yeah, but in a lot of those cases, we are going to penalize you on this, or we're going to bring it to court. You're given the bad actor in that case is essentially given a choice. We have found this, and we are either going to penalize you or we're going to prosecute you.
Well, I think they make a decision. They say, we are going to fine you. And then there's recourse. Or I don't think they would say we will do one or the other. I think they do one. They either fine or they say, look, this is really, really serious, and we've got to refer this to the county attorney, district attorney.
Right.
So I think they make a decision based on what they have found. And the idea, I think, is that they may choose to take no action, issue an admonition, assess a fine, or make a referral. That's the very nature of the body that has been created, and I think what we want them to do. So, all right, well, this is, let's look at what other codes provide to see if we are consistent with them, to see if it's addressed, and particularly at the model code. We are now at the 1 hour and 6 mark, hour and 3, I guess. And we have one more section on the agenda. If we can just take a quick look at that, and then we can review that, and then we should decide whether we need another meeting, an extra meeting next week.
On, sorry,
Go ahead.
I was just gonna say on point number 2 here. That's another place where the who needs to be consistent.
Where are you now?
Number 2.
Of what?
under tra- For training.
Oh, okay, we're in training and education. Okay,
I was kind of supporting your idea of let's just finish this one section. So
okay,
I jumped right in.
very good. All right. Exactly. And I've made the change under 18.2 consistent with our view that training and education is not the province of the ethics board, it's the province of the village manager.
Okay, can we talk about B?
Yes,
All right, so we're saying that the village manager should assist the ethics board.
that should change. It should be the village manager who does that.
Right, okay, good.
I
So
will
can we,
make that change.
yeah. Because I don't think, yeah, never mind. We agree.
Got it. And C,
You and I both made changes here.
yeah. And that, I think, is consistent with our intent to shift this to the village manager.
Yes, and the training materials to be reviewed by the Board of Ethics to
Yes.
ensure accuracy and completeness.
Right. Okay. What is,
Should,
What is everyone-
can I go back to that really quickly? Should
Yeah.
the ethics board be also involved in determining the efficacy of the materials that are being sent out on behalf of the village? You know,
Well, isn't that what C is saying?
I thought it was post reviewing. That's what I'm not clear about in that paragraph, whether it's post or pre.
Okay, so it should be prior to annual training courses, comma, the training materials will be reviewed.
Okay.
Does that satisfy?
Yeah, no,
your-
I mean, I just think that's, yeah, I think the ethics board should make sure that whatever is being distributed is, you know, effective, or
Yep.
at least, you know,
Yep, prior to distribution. Yep.
prior to the distribution, so that way there's no confusion later on.
any other comment on that?
Nope.
What is your view for meeting on Wednesday, or meeting midweek again, and on Friday, or meeting solely on at our regular meeting?
Oh, what I'm planning on doing next, since we've gone through the document. So if you could send me the latest version, Dan,
Yeah.
is to go back to working on the racing matrix. You know, and I'll do it section by section. And I think, you know, as a group, we'll need to review what I'm pulling from here and the who's responsible, et cetera, et cetera. So I don't know if you want to start doing review sessions on that sooner rather than later.
And Ellen, let me do some of the research that you said you were gonna do on like subpoena power while you focus on the racing matrix, because I have now ability to, I have a little bit of a lull with my regular work. So I can reach out to you to do some of the research comparing to other codes.
Sure. I don't know if you still have the email, but way back I sent out all the other codes.
I have them.
Okay, and
So I could either, we can connect after on just to make sure I have the notes from today's, what you were gonna take at, I'll let me do that. And then that will enable you to focus on the matrices, correct?
okay, great, thank you.
Okay.
I'm getting a sense that we all have a lot of homework and that maybe we should just, for now, schedule our meeting for next, our regular meeting for next Friday. Is that what am I accurate on that?
That works for me.
All right. And given that we will be, I hope, extended into January, it gives us a little more breathing room.
Yeah.
So with that in mind, is there any further business for us to cover today? If not, is there a motion to adjourn?
Make a motion to adjourn.
Second,
Second,
all in favor? Aye, raise hands.
aye.
Aye.
We are adjourned. Thank you all very, very much. Have a wonderful weekend, and I will send through a revised section based on the changes we've made, and we'll communicate and meet next week.
Okay, great. Thank you.
Thank you.
Have a good
Thank you
weekend,
very
everyone.
much. Take care.
Bye.
And it's against the law for an exempt employee. It's against the Fair Labor Standards Act for an exempt employee to furlough one day. If you work 1 minute during a week, you have to get paid for the entire week.